development has reached heights that people never imagined. And it is essential that the fruits of development be distributed amongst everyone according to the principles of equality, so that they would get the opportunity of enjoying development. Now, development, as I told you, is recognized as an inalienable right, inalienable human right to which all human beings are entitled to in the United Nations Declaration on Human Rights and also in the Rio Declaration. Now, what I wanted to demonstrate to you by that is that development is something that we should look forward to. Development is something that we have to be with, and development is something that we have to move forward. But like in all other cases, with development, there are many problems that we encounter. And it is this that we have to focus on, and it is this that we have to discuss in forums such as these. With development, one of the most important questions that arises is the damage that development causes sometimes to the environment. Environmental problems connected to development naturally leads to the issues of law and gives the law officers or the law to consider the steps that they have to take in order to see that development takes place without infringing upon the environmental rights of individuals. In the famous case, or that was an advisory opinion that was referred to the International Court of Justice by the General Assembly of the United Nations, Judge Veeramantri of Sri Lanka wrote a dissenting judgment. In the dissenting judgment, Judge Veeramantri said that the natural habitat is a heritage of mankind and that no one is entitled to meddle with it in a way that would be detrimental to the future generations. Now, this was a dissenting judgment that was given by Judge Veeramantri in the famous case where the General Assembly of the United Nations sought an advisory opinion from the International Court of Justice as to whether the usage of nuclear power was illegal in terms of international law. It is only Judge Veeramantri who wrote a judgment clearly stating that the use of nuclear power, if it affects the environment in a way that is detrimental to the humans, that it would be illegal. I thought I will start with the judgment of Justice Veeramantri because the protection of environment is something that has been highlighted in most of his judgments, in most of his writings. And environment, or the damage that is caused to the environment, is an issue that arises whenever we speak of development. The issue of development and human rights arose, or rather development and the damage that is caused to the environment arose directly in the case, in the contentious case before the International Court of Justice, which if my memory serves me right, that was a case between Slovakia and Hungary. The case between Slovakia and Hungary, where the issue arose as to how development must be checked when it affects the environment. Now, in that, Justice Veeramantri draws examples from Sri Lanka as well. He refers to the hydro projects that were established by the kings during ancient times, and he goes on to draw an example in order to demonstrate that whatever development took place during the time of Sinhala kings, that they were always mindful about the harm that was caused to development. And here it is very clearly stated that when we speak of development, we should be mindful of the damage that is caused to the environment, but then the damage that is caused to the environment is not a ground to reject development. That is something that we have to bear in mind very carefully. Now, the term that is used to strike a balance between these two extremes is sustainable development. Sustainable development is something which is accepted, which is highlighted, and this has become something very important in modern times. Development should be sustainable, and therefore development should not be unduly harmful to the environment. Now, when this issue arises, the laws of the 21st century legal research in the 21st century, legal innovations in the 21st century naturally become important. The reason being, whatever development takes place, that development must be within the frame of environmental law, which is designed to protect the environment from the ill effects of modern development. Justice Veeramantri, in this famous judgment, Slovakia versus Hungary, he says in National Court of Justice judgment, he says that we cannot think of development without causing any sort of harm or without interfering with the environment. Development is needed for the purpose of advancing society, for the purpose of ensuring that society gets the benefit of modern technology and science, and in doing so, and with the increasing population, increasing requirements of mankind, there is no way in which we could forget the damage that is caused to the environment and then proceed with development. And it is why the important issue of environmental sustainable development has been coined. We do speak of development, but development is always has to be within the framework of sustainable development, that is to say, which is designed to sustain the whatever advances that we make without causing undue harm. I think they have very importantly, they have raised the issue that whatever damage that is caused to the environment has to be taken into account when development projects are thought of. So we in Sri Lanka are mindful of this. We have our environmental authority. Whenever development takes place in our country, it is necessary that we call for a report from the environmental authority. And it is important that we give our minds to this and we do the research that is necessary for the purpose of making innovative changes in the steps that we take, always mindful of the fact that the development or the steps that we are taking towards development has to be within those limits. Now that is one of the most important things that arise in our progress towards development. What is important is that it has to be within the limits so as not to cause undue damage to the environment. Now the next most important thing is whenever we progress towards development, we have to be mindful of the socio-economic needs of society. If we are not mindful of the socio-economic needs of society, equality is one of them, then whatever development projects and whatever development processes we move forward through, it would not be so effective. I think on this occasion, something that comes to my mind, some words of wisdom, is the words of Prime Minister Tony Blair. When Prime Minister Tony Blair was addressing the Labour Party for the last time, before taking leave of the party after his long political career, he said, economic efficiency and social justice are not opposites. Economic efficiency and social justice are partners in development. And what he meant was that we cannot think of development forgetting social justice. All the laws that we make, all innovations that we make, all our researchers must be designed, must be directed towards ensuring social justice in our march towards progress. And that is where the law comes in. That is where the legal concepts of the 21st century become very important. That is where the 21st century lawyer is expected to guide development projects and to rethink of the structures whenever they think of moving forward in the 21st century. One of the greatest American presidents was the third president of the United States of America, Thomas Jefferson. Thomas Jefferson, when he was making his inaugural speech, he said something very important. He said, I quote those words, I have studied these words, and I will not forget those words because those words are so significant. Thomas Jefferson said, we are convinced and we act according to that conviction, that our interest with individuals as well as with states, soundly calculated, will be found to be inseparable with our moral duty. I thought I'll mention this fact, that is because in most instances what we do is, whether it is legal development or whether it is development in any other sense, we tend to forget the moral duty which is attached to it. Whenever laws are made, we ought to remember that these laws must have as their foundation the moral obligation that you have towards society. If you move forward oblivious to the moral obligation that you have towards society, then I'm sure that your laws will be found wanting in your march towards progress, in your march towards development, because they would not fulfill the most important requirement, that is the requirement of protecting those vulnerable groups and vulnerable sections of society. Now, when we speak of development, we speak of rural development, we speak of development for the purpose of providing for those who are in need. We also speak of development for the purpose of moving forward with society. I can remember once in a very special speech, Kofi Annan, the then Secretary General of the United Nations, went on record saying that 45% or 50% of the population of the world has yet to take a call or receive a call. Now, what he wanted to point out was the equality, the inequality that is involved in all this development, because the fruits of development have not reached those sections, those segments of society who need or who are entitled to enjoy those fruits, simply because we have not thought of them in the development of our legal laws which govern and regularize development. Now, the third important thing that is absolutely necessary in the march towards development is that we do not forget the impact on human rights. Human rights today has become a topic which is always spoken of. You cannot think of any legal structure, you cannot think of any legal format devoid of some sort of human rights flavor in it. Human rights have been defined by a right to which every person is entitled to by virtue of the fact that he is born a human being. And human rights have been defined in such a broad way. Therefore, in our development efforts, in formulating our legislative structure, in formulating our legal structure, it is absolutely necessary that we considered the human rights which are affected or which in some way has some sort of detrimental effect on the development that has a detrimental effect on the rights of those people. I'm speaking of right to equality. I say so because when we speak of development, we do not think of what a segment of society would be requiring, a segment of society that would be looking at. And it is the reason why it has been said that it is necessary that we focus on human rights also in all our development projects and all our development law. I think these are three major areas which have confronted the lawyer of the 21st century. These are some major areas which have to be taken into consideration in formulating laws in order to meet the challenges of the 21st century as we move forward through development due to the science and technological advancements that we have made during the past. The three areas that I highlighted are, firstly, the damage to the environment. Secondly, the socio-economic problems that arise as a result of development, socio-economic problems. And the third is the problems that arise as it directly impacts upon certain rights which are considered to be rights to which people are entitled to by virtue of the fact that they are born human beings. I think this is the challenge that is faced by the modern lawyer. This is the challenge